This case concerns the standard of proof to be applied in police disciplinary proceedings resulting from the killing of a civilian by a police officer, where the police officer maintains that he was acting in self-defense. W80, an armed police officer, shot Jermaine Baker dead in a police operation. Mr. Baker was implicated in a plot to release 2 prisoners from custody. The police had intelligence that the plotters would be in possession of firearms. W80's account was that during the police intervention, Mr. Baker's hands moved quickly up to a shoulder bag on his chest. W80 fired 1 shot, he says, fearing for his life and those of his colleagues. Mr. Baker was killed. No firearm was found in Mr. Baker's bag, but an imitation firearm was found in the rear of the car. After Mr. Baker was killed, an investigation was conducted by the Independent Police Complaints Commission, the IPCC. It concluded that W80's belief that he was in imminent danger was honestly held, but unreasonable in the circumstances. Applying the civil law test, that any mistake of fact could only be relied upon if it was a reasonable mistake to have made, the IPCC held that W80 had a case to answer for gross misconduct. It sent that recommendation to W80's employer, the Metropolitan Police Service. The Metropolitan Police considered that the IPCC had been incorrect in applying, in this case, the civil law test of self-defense, which looks to whether an honest but mistaken belief is reasonable, as opposed to the criminal law test of self-defense, which looks to whether the belief is honestly held. After the Metropolitan Police indicated that they would not follow the recommendation to bring misconduct proceedings against W80, the IPCC, now known as the Independent Office for Police Conduct, the IOPC, directed them to do so. It is that decision which is challenged in this judicial review. The Divisional Court held that the criminal law test applied. On appeal, the Court of Appeal held that neither the criminal law test nor the civil law test applies, but that a tribunal in police disciplinary proceedings should simply apply the test contained in Schedule 2 to the Police Conduct Regulations 2012, namely whether the force used was necessary, proportionate, and reasonable in all the circumstances. Officer W80 appeals against the decision of the Court of Appeal, arguing that the criminal law test applies in police disciplinary proceedings. The issue before the Supreme Court was, therefore, whether it is open to a reasonable disciplinary panel to make a finding of misconduct if an officer's honest but mistaken belief that his life was threatened was found to be unreasonable. The Supreme Court dismisses the appeal, unanimously holding that the test to be applied in disciplinary proceedings in relation to the use of force by a police officer in self-defense is the civil law test. Interpreting the standard of professional behavior in the 2008 and 2012 police conduct regulations, the Supreme Court concludes that the civil law test is the correct test, giving 8 reasons for this conclusion. First, the standards of professional behavior set out in the 2008 and 2012 regulations are each framed as statements of objective fact. For example, one standard is that officers act with integrity. Accordingly, the standard in respect of the use of force should incorporate the degree of objectivity sought to be achieved under the regulations. The civil law test is more appropriate to this end than the criminal law test, under which self-defense is addressed on the basis of the facts as subjectively understood. Second, the word knowingly, which had featured in the appropriate standard for police officers in relation to the use of force contained in the 1999 and 2004 regulations, was omitted from the 2008 regulations and subsequent regulations. When the word knowingly was deliberately omitted in the 2008 regulations, this was a strong textual indicator that the test to be applied thereafter was the civil law test. Third, the purpose of the disciplinary arrangements in the 2008 regulations is not simply blame and punishment, but also achieving learning and development for the officer based on an employment model. This suggests that the civil test is more appropriate so that the reasonableness of mistakes can be subject to a disciplinary process. Fourth, the standard of professional behaviour as to the use of force in the 2008 regulations prevails over the Code of Ethics, which incorporates the criminal test. The Code of Ethics expressly provides that in misconduct proceedings, the formal wording of the 2012 regulations will be used. Fifth, paragraph 4.4 of the 2012 Code of Ethics, which incorporates the criminal law test, is wrong and misleading, as it does not reflect the test in the 2008 and 2012 regulations. Sixth, the obligation placed upon the IOPC Director General to have regard to guidance published in 2014, which relies on the Code of Ethics, cannot mean that the Director General can disapply the 2012 regulations. Seventh, the test to be applied in England and Wales under the 2008 or 2012 regulations is not informed by the different provisions governing police disciplinary proceedings in Northern Ireland and Scotland. Finally, the test in England and Wales is not informed by Article 2 of the European Convention on Human Rights, which would not demand the application of the criminal law test in any event. The Supreme Court concludes, therefore, that the test to be applied in disciplinary proceedings in relation to the use of force by a police officer in self-defence is the civil law test. The IOPC applied the correct test when directing the Metropolitan Police to bring disciplinary proceedings against the appellant. Accordingly, the appeal is dismissed. Court is now adjourned.